Good morning, everyone. Welcome to the book event held by our Center for Legal Innovation and Digital Society here at CUHK Law. As you might have already read from our poster, this event is about a book on Web3. Today we have a very distinguished group of panelists share different insight about the book. So let me have a very brief introduction to our panelists today. On my left-hand side, this is Mr. Simon Hawkins, who is a partner at Latham Watkins. And next is Dr. Joseph Lee, my collaborator, who is a reader in corporate and financial law in University of Manchester. And you can imagine he flew all the way from UK here for this event. And our lovely Professor Elisa Mick here at CUHK Law. Equally lovely, my colleague, Professor Jingyi Wang, also here, our resident expert in tax law, and my beloved colleague, Professor Norman Wislap, who is an expert in data protection as well as torts law. And online is also our collaborator that you can see, Professor Runhua Wang, who is an assistant professor in University of Macau. So without further ado, I'm now getting into the book project right now. So this is a collaboration between CUHK Faculty of Law and the University of Manchester School of Law. So I am now inviting Joseph to introduce this project to all of you.
Thank you, Zhan. Thank you, Chair. Is it on? Yes. So thank you very much for inviting me to Chinese University of Hong Kong again. And it's really a great honor to be collaborating with the Chinese University of Hong Kong and with Zhan Li, such a great scholar in the world in intellectual property and digital law. So I can't remember how many years ago that the University of Manchester and Chinese University of Hong Kong launch a kind of CCON fund for research collaborations, and so both of us would then seize that opportunity, and we applied and it's been shortlisted, and we also obtained that funding. So we're one of the very few researchers receiving this fund from the social science and disciplines. I think majority of them are doing, I don't know, sort of semiconductor, quantum computing, that kind of research. So I think we were the only, very few of them to have received from social science departments who have received this fund. So I'm sure that they actually liked what we were doing. And so we started the collaboration, and at the same time, there was also another opportunity to work with our partners in mainland China, and there was funding provided by the British Council. So at the same time, then I was talking to Zhan, said, hey, why don't we actually, have we applied and then to bring our partners in Asia to our project. So then I applied, and also bring my colleagues from University of Manchester to work with colleagues mainly from CUPL, Chinese University of Political Science and Law, Professor Dai Long and Professor Shi Jianzhong, but also other colleagues from Capital Normal University, Yonghui Bao and Professor Li, to work with us to join our project. So, but then we also, reach out to other universities in the UK and also in Europe to join our project as a as a collaborators. So we started the project, and at the beginning we were looking more around sort of digital space, digital law, but we're struggling to think about a theme that can actually captures everyone's eyes. And then we thought, okay, I think Web3 seems to be quite interesting because nobody knows what it is. So we started looking into what Web3 is. We talk about Web 1, Web 2, and Web 3. And then from that, we also looked into Metaverse. I think that was one of the projects about 2 years ago that Zhan started here as well, and I was also quite honoured to be invited to join that conference. So we have quite a lot of activities between then and now, and also the future. So we have a number of meetings and conferences, and the first conference was actually held here at the University of Hong Kong. At that time, we had to wear masks. Can you imagine? That was the time, the very first one. By law, we all had our meeting. If at least if you remember, Norman, you were here as well. We have to all wear our masks, and we can't even take it off. Even when we want to take a group photo, and the dean say, "No, you have to have your masks on." So that can you imagine? That was the period. No one was actually in person. Everyone is online. So that was the period we actually started the project. And then I think then the rule relaxed. I think the second one we could actually take off our masks to take photo, but then I think inside we still have to wear masks. And then we also had a conference in Manchester, and with our colleagues, not just academic staff, but also PhD students, to Manchester, and also with our sort of local practitioners and tech developers to join our conference. And there was just one sort of unfortunate thing, that Elisa, wasn't there at our conference because she was in Madrid, Manchester, Madrid, so she actually preferred Madrid. But then it was really, we had a fantastic an opportunity to continue sharing our sort of interim findings with our academic colleagues, and also with the industry partners, practitioners like Simon, and also with tech developers in Manchester. As you know, Manchester is the second largest tech hub after London in the UK. So that's what we have done at that conference, but we continue working on our projects and our findings. And then because we are CUHK is actually very good at promoting our projects. So even though our final book has not published yet, I was actually contacted by the UK Parliament, by the I can't remember the full name, it's kind of a science research department, and they want to produce a brief to basically to brief our parliamentarians in the UK about Web3 and metaverse. So they reached out to me, and so then we shared our sort of interim findings, because at that time the book wasn't out yet. So and then we provide some of the evidence for them to write up their parliamentary brief. And so then our project was cited, and some of our papers were also cited in that parliamentary brief. So I think that's part of our sort of engagement with the industry and also with the third sector. And I can't remember that when, I think that was sort of later last year. And then this year, then our book was out. And then but I think this is not really the end. I think this is probably just the beginning. We also want to use the findings and also the activities that we have done. We have also published them online, and to continue engaging with the academics in the region, and also with the industry partners and with the third sectors, for example, the government agencies, and to see what we can do to continue that project. In fact, last year the CUHK's senior management actually had a delegation in Manchester, and I actually made a presentation to the senior management about our project, and I think there was a delegation led by Provost Professor Alan Chen, and also the Vice Chancellor for Research, Professor Andrew Rawlings. I think that was, yeah. So, and also with many other senior management. So we presented our interim find. I presented on behalf of Jan and also others in Manchester to our senior management. So that was a great opportunity to actually showcase that how should I say, there's a future for this research, and hopefully there will be more support coming from Manchester and also Chinese University of Hong Kong. I don't know whether senior management is here, so hopefully that you can continue supporting us, and we will definitely grow this project. And now we'll look at Web3, but then there will be other, quantum computing, probably the next one, and God knows what is going to happen later on. So hopefully that we'll continue getting support from the university, from the government, from the tech sector, and also from the industry, from the law firms, to continue working with us, giving us feedback and see whether there's opportunity for us to continue a project on digital law. So I think I said too much, so hand it over back to Jan. 谢谢.
Of course, so we can have more time, so it's not too much. So as Joseph said, so this has been a wonderful collaboration between CUHK and Manchester. And I also want to highlight, so the Web3 project is actually one of the two major research projects the research center has conducted in the past 2 years. So the other one, also mentioned by Joseph, is that we have a Metaverse research project, so which also come from a conference. So a lot of us were actually in that conference as well. So that is another collaboration with Melbourne University as well as National University of Singapore, the Trail Research Center. So we have also a special issue with Northern Law School's Media and Arts review. And yes, so Joseph, you are right. So I still remember, so when we first started to have this Web3 conference at CUHK, so we still needed to wear a mask. And we have that idea, we probably need to do the conference in the Metaverse instead of in person. So that is why we have another conference on Metaverse. And we actually co-held 2 conferences. One in CUHK, the other in Manchester. And Elisa, so he always remember your absence from the Manchester conference. Right. So now let's get into the substance. I want to start with Jimmy because I always remember when I practiced the law long ago. So I always feel tax law is really challenging. So whenever there's any tax law part in the case that I'm handling, so I actually know nothing. I can only rely on tax law experts. So my practice covers both company law, IP, but I can never do tax. And that's why I always feel probably tax law is one of the most challenging area. So when we study Web3, Jenny wrote a very beautiful chapter about tax treatment of all these different kinds of crypto assets. So I am really curious, especially like Bitcoins and other kinds of crypto assets, because they are sometimes very, very volatile. So I want to start with Jimmy's chapter. So can you explain to us how the very nature of crypto assets affect taxation or the application of tax?
Thanks, Jan. So first of all, thanks Joseph and Jan for your kind invitation. So I had the great opportunity to take part in this very interesting and cutting-edge project. So I myself learned a lot by writing the chapter. Right, so thank you very much. So talking about tax treatment of a cryptocurrency, I think it's a very interesting question because cryptocurrency itself represents so many different features from traditional assets, right? So different countries try to think about a proper way to tax cryptocurrency, especially after the valuation of Bitcoin has increased so much over the recent years. So investment into cryptocurrency has attracted enormous attention, not only from investors, but also from tax authorities, right? Because tax authorities also want to get their fair share from this stock of enormous value. So I would say there's no unified approach of taxing cryptocurrency currently in the world, right? So there's different countries take different approach. If we can draw a spectrum, we would say there's someone in the middle, okay, who just try to apply the current taxing approach of traditional assets into cryptocurrency. Okay, so they just try to catch every transaction of cryptocurrency. Okay, but then on the other two sides, there is cryptocurrency heaven like Hong Kong and Dubai. They exempt cryptocurrency related again totally. Okay, but on the other end, there are also very interesting development, especially in Japan. In very recent years, Japan started to expose very high tax rate on crypto assets, even on unrealized gains. Okay, so I think this make the taxation of cryptocurrency a very interesting question to pay continuous attention to. So I think thanks for the opportunity again. I will continue to work on the topic. Thank you.
Thank you, Jim. Now I want to shift to Renhua, so who is with us online. Renhua contributed a chapter about non-fungible token, the so-called NFT in this book. I am lucky enough to be her co-author, and the other co-author, Dr. Jingwen Liu here, is also with us. Renhua, so I know that you are now in charge of the research center in the University of Macau about empirical legal research as well as AI. But for the chapter that you contributed about NFT, so we read a lot about NFT from different media outlets, but I'm sure still a lot of people have no idea about what exactly that is. So I met some investors who spend a lot of money buying NFT, and I asked them, so what did you buy exactly? So what is the right that you have with that artistic work? But a lot of them actually have no idea. So I want to ask Renhua so about the legal nature. So if I have something that is really amazing and hard work. So does that mean that I necessarily have the right to create an NFT from them? Or if you use the professional term, so who have the right to mint an NFT?
Thank you, Jian. And also, I appreciate this chance to collaborate with you and Jingwen again. And thank to Joseph for providing this opportunity. Mm, Actually, this book chapter is a sister work to our article, a journal article, talking about the interplay between IP law and NFT. And we also discussed the technological and legal nature of NFT in that journal, but because of the limited space and we didn't have enough chance then to really explain thoroughly, or we actually have more things to discuss and really appreciate this chance to have this chapter to finishing the story and highlighting the technological nature and legal nature of NFT. For people who have invested in NFT in this area and what they really actually bought and who have the right to mint, and in this book chapter, we use the some definition to explain what you actually have minted in NFT could be property or assets that relates to technology on blockchain, but actually that do not mean when you purchase an NFT, you actually receive the asset or property rights attaching to the asset. When we call someone mint NFT, that actually you can think about to hash or create a series of digital numbers on blockchain for a piece of property, personal property, real property, or intellectual property. And what actually you can receive either a piece of property or a smart contract. It really depends on not only who created the initial NFT, but also whatever created within or on blockchain. In the book chapter, we made a comparison between the NFTs included, all of the details, all of the whole piece of the art addressed in or addressed on blockchain. And for that situation, and we would make a close comparison between those NFTs with a personal property. However, in most of the circumstances for energy saving or practical concerns, and most of the time, and digital property are only hatched their URL links on blockchain. In those circumstances, and consumers, they only receive the tokens itself and without receiving any interest on the intellectual property attached to the NFT. And another important legal feature for you to consider what you have received is whether or not the NFT can be interoperable across blockchains. We have seen cases that probably someone uploaded or minted one NFT on one blockchain and later on create another NFT on another blockchain, and they are not interoperable. However, they may share the same owner or different owners and creating various legal issues. In that circumstance, is direct evidence and showing owning an NFT actually does not suggest owning any asset rights, property rights, and for the property attached to that NFT. So that are the notices or reminders for investors in this area. However, we have seen because of the flourish of NFT, the market, and a lot of IP or artworks, and have been broadly stand on blockchains and over different physical areas. In that circumstance, we have seen the pro side, that is to have a great advertisement of many artworks. On the other hand, and we also go back to the original question, who really have the right to mint, create an NFT. And here we want to remind whoever created or purchased NFTs, and if you don't have any relationships with the IP holders, and there could be potential legal issues regarding IP issues, and especially copyright infringement. We have seen cases, and not only copyright issues, but also trademark issues. And all of those cases suggest that it's better to have original IP rights over those intangible property, and to have the right to later on to mint and transact NFTs associated with those IP works. Basically, that is the chapter we shared, and we have two cases addressed in the chapter and to support our arguments about the technological and legal features of NFTs. Thank you.
All right, thank you, Renhua. Joseph just mentioned some of the chapters in the book have generated some policy impact in UK. So I also want to add up a little bit on that. So our chapter on NFT, the view in that chapter was actually cited by the US Patent and Trademark Office, as well as the US Copyright Office, in a report presented to the US Congress last year. So that is another different aspect of our policy impact from this book. So Renhua mentioned blockchain, and I think unavoidably we have an expert about blockchain as well as smart contract here. So everyone know who that is. So that is Elisa. So Elisa, so with regard to smart contract, so we know that you always educate all of us. There are a lot of misunderstanding. Can you elaborate? So what are these misunderstandings?
All right, guys. because everybody's like telling me that I was horrible not coming to Manchester. I was hanging with Satoshi Nakamoto on his private yacht. So sorry, I have priorities. Okay, now seriously, okay, on the serious side, I had to deal with smart contracts from, I think, 2011 or 2012. So I've been in this for a long time. I remember I started when the price of Bitcoin was about $250. And people were telling me, buy. And I would say, $250 for Bitcoin? I can buy shoes for that. You're so stupid. Okay, I wish, yes, because if I had listened to my colleague, I would not be here with you. Okay, sorry. But seriously, okay, there is a bit of a, I'm not just being funny, there is a bit of a point here. So I've been doing this for roughly, 13 years, maybe 14 years. And the most amazing thing is, in May 225, we still don't know what a frigging smart contract is. I mean, I think I know, but there's so much disagreement because the problem is there are technical definitions and there are legal definitions. And lawyers and regulators, hallelujah, for some reason decided to completely, 100% ignore technical literature. And technical literature, and I'm talking like the proper technical literature, not some white papers, they define smart contracts as distributed applications running on blockchains or the back end of distributed applications. There's like two leading definitions. So it's basically a type of computer program that can run in a distributed environment. How is that a legal issue is completely beyond me. But of course, the problem is, like, as I said, lawyers, regulators refuse to take note of the technical definition. And a couple of years ago, I did this review. We counted with my friends 25 competing definitions. Now, many of you will think, oh, okay, that doesn't really matter. You're just being academic, and this is all, like hair splitting. It's semantics. No, it's not semantics, because the problem is when we do a legal analysis, or even worse, when we start regulating, we need to be on the same page and we need to know exactly what we are regulating. So what is the regulatory target, yes? So this is kind of obvious. So you see the problem when everybody's talking about different things. You see this in the US at state level, because many US states have their own have their own crypto regulations, nothing on federal level yet. I just double checked with Simon, but it's coming, I hear. But on a state level, we have, again, completely different definitions depending on the state, which in my humble opinion is absolutely, let's just face it, idiotic. Because then when the federal law comes in, I have no idea what's going to happen. Because how do you even reconcile if everybody's talking about a different thing? You see the same thing in the UK, where it gets even more entertaining, where we have this beautiful report of the UK Law Commission based on this big project where they basically ask the public, where they kind of say smart contracts are computer program. Oh, but because we don't have enough confusion, let's add one more definition and let's have smart legal contracts, which are defined as computer programs used in the formation and performance of contracts. So basically every vending machine and every trading algorithm is a smart legal contract. So I have no idea what this really contributed. This is what my chapter is about, that everybody's avoiding the problem that we are basically wasting time instead of relying on clear technical definition. For some reason, academics and regulators like making up their own thing. Thank you. And by the way, buy the book. Okay, seriously, guys, this is not something that AI could have written. This is thousands of man-hours of expertise, analysis, and proper human reasoning. Buy the book.
Thank you, Lisa. So we still have a lot of misunderstanding or the need of information about smart contracts, so we will get back to you later. But since you mentioned Simon So who's the only expert in practice on this panel? So I'm sure that Simon probably knows much more, much wider about Web3. So in terms of what's happening in the real world. So Simon, can you share with us? So what are kind of like the major practice in relation to Web3, probably in the past number of years?
Sure. So I think in my practice, we look at both the centralized projects, so exchange of infrastructure, token issuers, etc. And then we look at the DeFi and pure Web3 projects as well. One of the things that comes up most often really is around structuring. So a decentralized autonomous organization doesn't have to be a legal entity, right? It can just be this kind of technological thing that exists and tokens are issued and you give the token holders rights to do certain things. The difficulty with that is it can't really function in the real world. So if you're actually operating a business where you need people to develop IP, you need premises, you need you want to do sponsorships, you want to pay people in a currency, you want to have predictability around how those people will get taxed for from an income perspective. You need to create a structure with a legal wrapper. So then the question becomes, where do you form that legal wrapper and what form does it take? And it then becomes very difficult, and we look at lots of different jurisdictions. Web3 has this herd mentality, being kind, I think, but the industry will follow a successful peer. So Ethereum Foundation is the best example. They set up a foundation in Switzerland. Foundation models in Switzerland have very strict rules attached to them, and they're not really suitable for a lot of projects. But a lot of projects said, well, Ethereum's set up there, and they haven't been sued, they haven't been enforced against by the SEC, so we'll go and set up a foundation there. But whether that's fit for purpose for the specific project is a very different question. And so we have structures now where there are Swiss foundations, they work for some people, Cayman foundations, that's a very common structure in Web3 now. BVI is another one. Singapore, people have looked at Hong Kong, but Hong Kong's not a great place to set up a foundation. And then there's places like Panama, reputationally very problematic, from all angles, actually, if you're dealing with US or EU counterparties. So in the structuring, we'll look at where is the best place to set up your legal wrapper foundation? Where is the best place to issue your tokens from? So it may not be the same entity as the foundation. And if you have a Cayman foundation and you issue tokens, you need to go and get a license. So most of those foundations will set up a subsidiary or an orphan BVI company that becomes the token issuer. The question then is, you've got to start with some investors. You need money, you have to develop IP. Investors will come in, and often they want equity, and they want to know where the value is in this structure. So where is the value? Is the value in the foundation? Where's the IP developed for the product or the service, or whether it's a DeFi exchange or it's some other DeFi platform? Who's producing the IP? Who owns the IP? And where does the value accrue to? And how do you explain that to someone who wants to come in and give you funding to actually build this business? The incentives for an equity investor may be very different from a token holder. The rights that an equity investor wants may be very different from what the governance rights that you want to give to a token holder. These are all things we have to take into account. There's no right answer, but there's lots of different kind of structural issues, and we could speak for 6 hours on this topic and still not cover it all. It's things that we spend days and weeks and months thinking about in practice and helping to execute those structures for people. So that's kind of it in a nutshell. Then on top of that, you layer on all of the regulatory concerns around the token characterization itself and how these businesses operate in practice, where the tokens can be distributed. And in the past 6-7 years, the regulatory risk from the US has been extreme. It's now changed, that risk profile has changed, and we will be the crypto task force in the US was mandated on the 5th or 6th of January to come up with a plan, a practical plan for how they propose to create a regulatory framework for crypto generally within 180 days, which will be the end of June or something like that. So that will be very interesting to watch, very interesting to see how the market reacts to that too. So that's kind of, in a nutshell, some of the issues that we can grapple with in practice.
I also have a lot of questions, so but we will talk about that later. So Simon mentioned about DeFi. So as we can see from the Web3 world, so a lot of the so-called platform or intermediary disappear, but we also have some new platforms. So we have a very important chapter in the book, so which discuss the legal liability arising from platform. So platform has been a major focus since Web 1, and now we are in Web 3 era. So still, we do see some new and old legal issues. So that is the chapter contributed by Norman. So Norman's chapter is very unique because it does not focus on kind of like the one direction or unilateral way from platform to user. So it actually more focus on the interactions facilitated by platform among these users. And there are new different kinds of liability issue. So I would now invite Norman probably to explain more about probably the essence of your chapter.
Yeah, happy to. So yeah, well, thanks again for inviting me to contribute. I should mention at the outset that my chapter is co-written with Dr. Nirav Srivastava from Deakin University in Australia. And basically the essence of our chapter is to look at liability for physical harms where platforms bring together people to meet offline in the real world. And the kind of scenarios where that happens is if you take a ride with the ride-sharing platforms, if you use a dating site, if you use basically some short-term accommodation and something goes wrong in that relationship between user and user. We know that platforms usually say that they just brought the people together, but they don't really have anything to do with what happens once people actually meet. But actually they do a lot more than that, So because they shape that relationship, they have a lot of rules on how you can interact, who you can meet. They have a lot of knowledge about users. They can identify people that are potentially at risk. For example, that Uber has a lot of control over its drivers. They've got systems to identify fatigue. And the same applies in the dating context on Airbnb. So there are often red flags that a platform has, and whether it responds to it or not is a separate question. And the chapter that we're in the chapter, we looked at whether that, basically that knowledge and that potential for control can also sometimes create legal responsibilities. And so what we've done is basically what we often need to do when there's a new technology or relatively new technology or new social development is where we've got old laws, but we need to check, before we call for new laws. Is it not perhaps already possible under existing law to regulate a particular area? And in the context of tort law, that means to create liability rules that are fit for purpose. And in the chapter, we basically did some, some quite systematic research in potential basis of liability. Of course, we're talking about tort liability largely. It could be contractual as well, but we focus on tort. And then look at, what are the potential bases of liability. It could be primary liability, it could be vicarious liability, it could be liability on the basis of a non-delegable duty. And so we go through those various options, and actually it's quite, as you could imagine, it's quite complicated. There's no single answer to it. It depends very much on the platform and the services that it offers. It depends on the user context. It depends on, of course, if you have, let's say, an Uber rider, they are providing a professional service. If you meet someone through a dating platform, that is a more personal relationship. So there is actually quite a lot of nuance to it. And in the chapter, we try to explore that. And ultimately, what we call for in the chapter is to say, well, actually, so it's platforms make it for themselves a little bit too easy by saying we don't really have anything to do with that because they do have control, and where they don't do what a reasonable platform would do in the circumstances to protect the user, they can actually incur, in particular, primary liability for their own misconduct. So that's, in a nutshell, what we did in that chapter.
I'm sure that's very important because nowadays I watch a lot of Netflix episodes about the problem for people to use these different kinds of application, dating application, for example. So this is of course important, and that has actually bothered a lot of us for many years. So I'm just curious, Norman. So is there a wider implication about this chapter? Because I understand there has been some new development, so in UK and in EU with regard to case law as well as legislation. So can you explain a little bit about that?
Yes, so basically, I mean, we know that platforms for a very long time, and actually to the present day, in most countries are in a privileged position. They're online intermediaries, and in the US and in the EU and in many other jurisdictions, they enjoy an immunity for content that's put on platforms. So the idea is that we don't want to impose on platforms an obligation to monitor what other people post on that. And it comes from the very olden days of basically the online economy, where this was actually very hard to do, and we did want to, in a way, not stifle innovation, but in a way encourage new forms of digital communication, digital interaction. But what has happened more recently is, well, we do know a lot more about the dangers, the online harms that can be caused. And also platforms have a lot more opportunity through AI and other mechanisms to actually do keep monitoring what was going on in platform and to moderate it. And we know that they do. But what they still cling on to is the idea that they should not be liable for it, that they have to be informed, and then notice and take down. So if they have been made aware of a particular violation of any device, well, then they have to respond and so on. But we know that, basically the Online Safety Acts in many jurisdictions in the UK and in Australia, Digital Service Act in the EU as well, put more of a burden on platforms to actually monitor what's going on and to protect users from online harm. And it actually fits into that, so basically, because we have to, in a way, what we had to do in the chapter is, in a way, to argue against some perhaps very long-standing forms of protecting platforms that I think have outlived their usefulness. It doesn't really quite hit our topic because we were interested not so much in online content, but in conduct and in the design of platforms, so rather than, it's the harm is not through what is published online, but is in the interaction that follows, and basically it was just, the online communication that basically set that process into motion. And in Australia, for example, this is often called now online enabled harm. So it's an extension of online harm, offline harm that has been enabled through what has been going on the platform.
Right, great. So platforms are mostly companies or business organizations. But in Web3, we also have a very innovative form of organization, that is the so-called DAO. So we have a super interesting chapter contributed by Joseph. So Joseph, can you explain, so what exactly is DAO? So how it's different from existing business organizations that we learned before?
Well, what is a DAO? I think the first time when I came across this term, DAO, and then I think there was an article that says, what is the yin and yang of DAO? And then when I start talking to people, that's, people asking me, so what's your current research? So I'm actually researching into DAO. Is that, Taoism, yeah, that's very interesting. Not exactly, but then, so I think again, what is a DAO? I think it is a term has been used by many years ago by people just start using that, a DAO, a maker DAO, and then people start to look into what exactly it is. Some people say it's a decentralized autonomous organization, or I think that's the common understanding of what a DAO is, a decentralized autonomous organization. But what exactly it means, what aspect is decentralized, what aspect is autonomous, and then what kind of organization it is. And when we talk about organization, even if there's no physical structure, there's some kind of collaboration, some kind of relationships between the participants. But then I think in DAO, I think part of it is because they don't need to register, so it's very difficult for us to know exactly what they are doing. And so we can only, researching on the website to see what people are doing in terms of DAOs and see what exactly they are doing, or what they say they are doing. But then there are also projects or activities or organization. They are doing similar things, but they don't call themselves DAOs. So I think these are also the very interesting space, and they've been called themselves some kind of platform or whatever, space projects, but then they use very, very similar structure or arrangement to DAOs, where you bring people, including artificial intelligence, from different jurisdictions and areas, and contributing to what they have in return for something. It could be called a DAO tokens. And so I try to kind of visualize what it is. It's like a digital enterprise or projects leveraging on smart contracts or other technologies such as DLT or Web3 or without Web3 to further a project. I think this is what I try to give a definition, if you have to give a definition. But again, it's still I think it may capture some, but then but not capture it all. But I just want to say there are lots of DAO online, but then they may not be DAO, or some of them are maybe even registered as a company and then operating like a company, so they're not exactly DAO. There are some, they don't call themselves DAO, but then it looks like a DAO. One of the very when I think about a non-platform, I think, for example, there's a dispute resolution platform called a CLINDS, but CLINDS is actually a registered foundation in France rather than Switzerland, and so they maintain a platform where you have there are creators, but they also have contributors writing computer programs to support the platform, because it is an arbitration or dispute resolution platform. So you also have the so-called jurors, and they can be randomly selected by program, artificial intelligence, and to make decisions on a particular case. And then in return, whether you are a program writers or developers or a jurors, depending on on how you'll be remunerated according to the protocols, and you will receive the tokens issued by CLINDS. So I feel it looks like a DAO, the way they interact with each other, the way they maintain that project. But then again, they don't call themselves a DAO. So I think to give a definition can be very challenging. And again, we have seen many jurisdictions, for example, in the US, there are DAO laws, and I think this is one of the projects that the Law Commission of England and Wales perhaps wanted to look into, but then felt it's a bit premature to do so. So I think as an academic, as a law academic, I try to understand what's going on and try to capture and then try to give a definition that is broad enough to to be able to communicate at least to the legislator, to the students even, what exactly it is. Sometimes it's not that we're ignoring the technical issues, but then I think sometimes the computer scientists they may describe the things that are not exactly what we can communicate in law, because in law we have to write the black letter law to capture what's going on, and then it's I think borrowing from the computer scientists, the terminology they use can also be misleading, and then it can be a bit confusing. And for example, now we're talking about artificial intelligence, and there are also people talk about quantum computing. Are they the same thing, or are they the different thing from the computer science discipline? Maybe they are very similar, but then for us, we don't think they are the same. Artificial intelligence is one thing, quantum computing is another, and then but then for a lot of computer scientists, artificial intelligence, quantum computing, what do they do? They're just optimization. But then again, for us lawyer, optimization doesn't mean anything. So it's I think because we have to assign a terminology that we lawyers can actually. We can process, and then we can, there are a lot of things that need to be grounded according to that, and according to, that definition. Then we can talk about registration, for example, or how to define the relationships between the participants within that project organization, and then how to define, for example, a token, from a proprietary or from other perspective or intellectual properties aspects. So I think it's very difficult to give a definition. I think we're probably not going to use a kind of probably have to give a more kind of impressionist approach to what a DAO is, and hopefully in a few years' time, if DAO exists, and then we will be able to know better what it is and probably give a better definition. But I think at the moment we probably want to, for the sake of communication, probably want to keep it as maybe a bit as broad, and then hopefully that's so we know what it is, and then hopefully that we can narrow down the definition. According to the policy, so perhaps there are certain DAO that we don't want them to exist, and therefore we basically exclude them from that kind of legal regime. Not necessarily they are not DAO, but we just don't want to capture them within the legal framework. It's very similar to how we approach digital assets. We use law, the legal framework to the fact that you give a proprietary definition to a digital asset, you kind of legitimize that digital asset. So, we're still seeing a lot of differences between how we approach that digital assets. For example, we're seeing, European countries, for example, Switzerland and in France, and also to a certain extent the European Union are giving sort of legal force to digital assets. But then again, when you're looking at China, they're still banned digital assets such as a Bitcoin, and of course not giving a legal legitimate definition or legitimacy to that digital asset. So I think policy plays an important role, and this is something that I think the computer sciences probably won't be able to help us, because I think legal definition involves policy thinking and also moral judgment as well. Yeah.
Right. I remember about 2.5 years ago, in our research center, we invited a very successful crypto entrepreneur to speak about DAO. And at that time, a lot of DAOs here in Hong Kong, so they are very closely linked to NFT. So what impressed me most was that the speaker refused to provide his personal photo for our promotion. And he just gave me kind of like a photo of very ugly monkey. And he said that is the NFT that he is very proud to own. And he said that monkey can represent him. And then that actually bothered a lot of our admin colleagues because we never encountered that situation before. And then that comes back to NFT again. So I want to ask Runhua. So of course, in the crypto community, especially the NFT community, so a lot of people, especially about 2 or 3 years ago, they spent a lot of money buying something like that ugly monkey, as I just mentioned. So what exactly did they buy? So did they buy any copyright, trademark right, or even license?
Very interesting, actually a historical situation, as we have seen the market of NFT is going down in the recent 3 years. That was the time NFT was super popular and people use NFT and the artwork attached to NFT to represent their personality sometimes in order to show which circle they belong to and whom they want to be closer with. For most of the people at the very first beginning of the stage and having an NFT, they thought when they purchase an NFT and they have some connections, especially property connection with the artwork attached to an NFT. However, after looking into both technological legal nature of the NFTs, and we can see like the only thing they hold is a series of number that is the tokens. And usually that depends on the licensing terms on NFT platforms. And that also goes with the smart contract features of the NFTs. And because usually smart contracts have limited words, and we can now see the details of what are the rights owned by the purchasers. So we really should consult for a platform licensing terms to really understand what purchasers or owners receive when they purchase an NFT. In most of the circumstances, and purchasers only receive a license to show they have some they are the owner of an NFT rather than any commercial user of the artworks behind an NFT. Regarding to the ugly monkey story, and that is a really a generous platform. They are the creators of those artworks, those ugly monkeys, and they authorize their user purchasers to commercially use those monkeys in different circumstances, and which also means and relatively those purchasers received or held a relatively broader rights compared to other NFTs relating to different other artworks. Professor Edward Lee at the United States made a great analogy between NFT and library card catalog. Actually, when people receive NFT, those tokens, they kind of like to receive a piece of card catalog. And the books behind the card represents the intellectual property or physical arts, which actually do not they are not received and also not held by the purchasers of NFT, and who are the possessors and who are the owners of the library cards. And that is basically what are the nature the nature of the NFT. So for the owners of those ugly monkeys, and fortunately, their platforms are more generous than other platforms, which doesn't mean like we have a constant nature or culture of NFT. when they were commercialized per se. Now we're talking that for people who probably want to use NFT to represent their personality or make some commercial connection with their business, and they really need to look into the platform's licensing terms, saying what are the rights and the platform authorize the minters and buyers to sell and receive and during the NFT transactions.
I think I'd just tag on one point on NFTs as well, which is I like the analogy about the library card, but I'd say that it's even more absurd than that, because you actually get the ticket, but the book itself, you may not even get the possession of it. You might get a photocopy of it. The book itself is in the library. The library can burn down, and then you just have the ticket. Because actually where the image data for most of these NFTs is stored, it's not on-chain. So if I have my NFT and I transfer it to Joseph, to his wallet, peer-to-peer, I'm transferring my NFT, the token itself. The token, there is no image data typically embedded into the code for the token. The image data is normally stored somewhere else on like an AWS web server owned by like another person who created the image by the NFT marketplace. And so if there's something happens, if the server goes down, all the image is lost, your token no longer connotes, it doesn't have anything to link to. So it then becomes effectively defunct. So that is, in addition to the points that have already been raised around, who actually owns the IP, who owns the trademark, for the actual underlying image. There's also the question of where that image is actually held if it's not, embedded as on-chain data.
Right, thank you, Simon. So I'm always very curious about the legal practice and the impact on legal profession. So with regard to Web3, because as we know, probably yourself included, a lot of the so-called Web3 lawyers, they come from the background of financial law. So what is the current situation for this Web3 practice? Because the issue you just mentioned covers different kind of field of law, so probably IP as well, different kind of art, so which is very different from the traditional understanding of security or financial instrument. So is there a kind of like a more specific, like for example, a team in most of the law firms focusing on Web3, or is still mostly covered by financial lawyers?
I think the practice is mixed. I'd say that for some of us, like my team, my day job, if you like, is financial regulatory lawyer, and I advise traditional financial institutions and all that kind of compliance stuff. But I probably spend 70% of my time on Web3 projects these days. My area still remains on financial regulation, so it's on the types of governance, structuring, token characterization, the laws and regulations that apply from a conduct perspective. But we've designed and launched many NFT marketplaces as a firm, and our Web3 group is a cross-disciplinary group of lawyers, most of whom, like we have our IP data lawyers, for example. They do IP data law across multiple industries, but some of them have become much more specialized in Web3 in the same way that my practice has kind of become more specialized in Web3. So, and then you have, in other firms, you have people who have just described themselves as Web3 lawyers, although I don't know how as a single individual lawyer you could cover the full spectrum of issues, because it's like saying you're a M&A lawyer, and then on the M&A deal you do the corporate documents, the tax, the IP, separation agreements, carve out, regulatory. Like there's no single lawyer who does that either. Mm-hmm. So it's a patchwork of cross-discipline experience.
Mm-hmm. So we have a number of students here, and other students might watch the video afterwards. So I think they are really curious about the future of legal profession. If they are really interested in this like Web3 kind of practice, so what would be your suggestion? Especially a lot of the students are now worried they might be replaced by AI.
Me too. I think for sure, like, you know, big parts of our job will be, we will use AI to do big parts of our jobs. I think if you are a student interested in practicing, you know, Web3 law, let's just call it that, you know, you look for a firm that has a good reputation and it has a solid track record of advising clients in that space. You know, there's most firms now will say they do this area of practice, but when you kind of dig beneath the surface, you find that really it's very shallow experience. So, you know, but there's other firms like mine, which, you know, has very deep experience. Most of us have been practicing in some area of crypto or Web3 since 2014 or before. I used to advise BTC China, which is the biggest crypto exchange in the world at one point in China. Now seems absurd because, of course, you can't even operate that business there. But there was a time when you know, that was an area of practice. So, yeah, look, do your homework basically on the firms, and, you know, reach out to people individually. I talk to a lot of students and others who are interested in this area in my free time. So.
Thank you, Simon. So when it comes to AI, so I actually have a question about AI to Norman and Jingyi, because Norman, in your chapter, it's not about AI, but nowadays we do see a lot of the platform operation is automatic because of AI. Do you see that will probably change your argument, or if your chapter also have implication on that kind of AI impact? And for Jingyi, of course, you wrote beautifully about the crypto asset. But for AI, I think there's also kind of like a big change because we have a lot of information that is automatically generated by AI. Even for IP expert like me, we are not sure whether that is property or not. But for sure, there are a lot of transactions about this automatically generated content. So I actually have no idea. So how can we handle tax issues with regard to that kind of AI generated information?
Okay, so maybe I make a start. You know, basically, yes, of course. You know, liability for the use of AI is a big topic and a very contentious topic. You know, so a lot of people are working on this, and I think no single solution has been found out. You know, it's a patchwork of different principles that you need to apply. So our chapter wasn't really quite like that. You know, it wasn't really about what happens if you use AI systems and something goes wrong. It doesn't respond in the way that you expect, or a particular outcome is you know, basically causes harm to someone. Yeah, it's almost the reverse what we did in our chapter. You know, so what we did in the chapter was basically, as I said, it's based on user-to-user harm in the physical world, but it could potentially have been prevented or made harder, in particular if platforms did more moderation, did more monitoring of interactions between users. So the issue was, in a way, the failure of using already available AI systems in a way that protects users from harm. And there's actually not much written on that at all. You know, so, but it's an emerging issue, you know, so, you know, and this, I think, talking about students again, this is a really popular topic for students who in their final years, and then they have, at least at, you know, Chinese, they have to write a research paper, and looking at particular aspects of AI liability, looking at that from, you know, in particular from a comparative perspective, and perhaps discreetly in particular AI applications, autonomous driving or whatever it may be, is a huge growth area, you know. So that's, you know, we didn't do that in the chapter, you know, but in some of my other work, earlier you mentioned metaverse, so of course there can be liability issues as well, for things that happen on the metaverse. And again, basically platforms or the operators of those, basically spaces, they have certain responsibilities to users, to protect them from both online harm or online enabled harm, as I mentioned before.
Sure. Thanks, Jan, for your very interesting question. So I think, given the suggestion by Elisa, I will first go back to check what is the definition of AI generated information, right? In order to make sure we are talking about the same thing, right? But I think it's, in terms of the value of the data, I think it's a very important question, right? Especially if we're talking about so many platform companies. Nowadays, probably most valuable assets of those companies are the enormous data maintained by themselves. So for myself, I tend to compare data to like a golden mine, right? So if you only own the data, probably there will be no tax liability. But the tax liability should be triggered by the commercialization of this data, right? So it's really depending on how the company or the owner of the data use those like data, right? So this is actually a very interesting area also in mainland China, because now many these high-tech company or platform companies, they simply like increase the value of their company by saying we own this amount of data, and then they use this data to borrow money from the bank. So I think it's a really interesting area, right? So if there's no commercialization, how the value of those data would be recognized? Mm-hmm. So I think this is definitely a very important and interesting question to pay attention to.
Thank you. So I have a last question. Initially, I wanted to ask Joseph and Lisa, but then I thought that might be a good question for every panelist here. Because Elisa and Joseph both mentioned about the opportunity brought by new technologies. So it's fantastic to have these new technologies. But on the other hand, so they also generate new types of risk. So that's why we lawyers need to think about what would be the role played by law, policy, and regulation. So my question is that for all these new technologies, because they are fantastic, they somehow help us to probably solve some of our problem in real society. But should we just leave them alone because they came from the market, so they are mostly kind of like a private ordering. They help us solve some of the problems. So in that sense, so the government should probably just take a hand of policy. So from a regulatory or legal policy perspective, but we always talk about the new regulatory approach to smart contract, to DAO. So what is your fundamental view about that? And I think that is actually a problem that we have thought about in different chapters, so by different contributors, and that is a biggest issue faced by regulators, scholars, and practitioners. So what about we start from Elisa, Joseph, and then probably this sequence.
Okay, you keep on using the word new. And the first thing we should check, are we dealing with sales and marketing talk, or is it something really new? Okay, because sometimes it is, or it might be new. So I think it's a question of fact. There should be a bit of an investigation what it is that we are dealing with. Okay, because AI, for example, and I hate the term, because it's either a multidisciplinary research field. This is the definition. It's a multidisciplinary research field that deals with ABCD. You can check the definition. There's a couple of textbooks on AI. And we tend to forget that each and every, without exception, each and every AI is a computer program. So I think we should look at the attribute, what changed, what's new, is the problem new? Sometimes it is new, and sometimes it's just a different way of doing the same thing. So I'm not saying that this book was not worth the while. There's nothing is new. Because, I mean, guys, the devil is in the detail, and, lawyers make money from the details, yes? So we have to understand the nuances and the details. And as I said, I think it's always a question of fact, whether something, and there is a lot of new stuff. Because, I mean, there are new activities or new ways of doing old things. But is it a new technology? Is it a new technology? Is it a new activity? And again, back to square one, what exactly are we regulating, the technology or the activity? If I forgot to mention, buy the book. All the answers are there.
Yeah, I think technologies are important for us, and that's why we're all leveraging on all the technology, the facility that's available for us. But I think in-person experience is also wonderful. That's why we are here talking to each other. And there are lots of things that you can't get through purely online, on-chain activities. I think there are lots of things that can happen offline and off-chain. For example, after the conference, we will be, we're going to be going for lunch and coffee, and we'll exchange words. I think there are a lot of things that we can pick. You can pick up, and then and I think this is where. The technology, sometimes they may capture something that is, depending on the data, the structured data, but then they probably won't be able to capture something which is not it's not in their kind of data library. And I think, and also depending on who designed that algorithm, I think, it's then the thinking, the process of that particular individual or individuals or DAO. I think from the DAO's perspective, I think this is where technology can be of great help. It can help to automate some of the processes, thinking about DAO as a project or as an enterprise. And for example, the project that I'm doing with the Jian, we need to do our audit. For example, every penny spent by a person's, we will need to, they're accountable, and it's quite time consuming. We have to do it manually. We need to report. We have to find the right final report detailing, how the money was spent, and then who spent it, what's the amount, where's the receipt. And it's quite a lot of work that we have to do for a small project like this. And for example, when you think about a DAO project involving probably not kind of 500,000 pounds project, if it needs to be audited for tax purposes, it can be quite daunting, and and they may need to go and see a tax lawyers for that. That's great, but I don't know how much tax lawyers charges them for a project like this. So probably eats up all especially they probably have to go to Simon. That's 3 days a week work, for a 500,000 pound project. So I think technology, it can be helpful in reducing some of the transaction costs, not all the transaction costs. Some of the transaction cost, especially the kind of work that nobody wants to do, and especially a lot of students now, they don't want to do due diligence work. They find it boring and not as interesting, just checking, going through, reviewing all the contracts. I think maybe this is the opportunity where technology, artificial intelligence can offer some value. Or, for example, we're all lawyers. We like to make rules. We like to make detailed rules. So. The compliance can be very challenging probably not so challenging for big enterprises like HSBC. They can actually fire 100 people and also Simon to do the compliance work and giving the regulatory advice. But the smaller project, for example, a DAO, let's say, for example, a DAO want to issue an NFT and they want to fractionalize NFT and issue tokens to the public. Well, do they need authorization from the financial regulator? Well, they will need to come to Simon for that advice. And I don't know how much Simon charge per hour, probably 100,000. Yeah. So it can be quite expensive for a small DAO, although they probably want to talk to Simon, but then they may not have the fund. And I think this is where technology can help them. So they can answer, especially for smaller projects, issuing, fractionalized NFT by way of tokens to the consumers online, and whether they need authorization or not, or what kind of licenses they need to obtain, and what sort of conduct issue they may be involved. I think that kind of technologies, kind of law tools may be useful for them to get the initial understanding, although, they will still need to get, they will still need to obtain license, and then there's still kind of nuance and knowledge that they may need to. And this is where they can go to Simon for a more kind of detailed advice. But then just kind of getting so I see the technology can act more like an in-house counsel or kind of in-house legal secretary to provide an initial understanding for DAO project developers. But then again, the more detailed rules, for example, if they're seeking authorization, or if they want the DAO to be sort of traded on a centralized platform. Now, there are lots of rules. For example, at the EU level, there's a MiCA, and in the UK, the Treasury has also drafted rules. So they will need to comply. They need to have a good understanding of how the rules work. And I think this is where seasoned lawyers would have that kind of knowledge to guide them. But I think that can also help DAO or digital enterprises to kind of to optimize their resources, and then they can actually use the resources for more sort of targeted legal advice. I think this is what the students want. I mean, students don't want to just kind of learn the very kind of boring rules. They want to have, they want to do something more interesting. Certainly, I think a lot of students probably don't want to do due diligence anymore. I think this is where AI may be able to help. Yeah.
Right, so, Simon, I guess most lawyers would prefer more legal intervention so that lawyers can make money.
Sure. I mean, sometimes the lack of laws is good for us too, right? We get to advise on ambiguity. I think fundamentally, like the promise of Web3, which sort of started with Bitcoin, and then Ethereum obviously kind of has scaled the kind of possibilities of what you can do with these digital tokens. But it fundamentally came out of this libertarian idea of being able to create value without relying on government and centralized intermediaries that are perceived as sometimes being barriers to accruing value, or just this libertarian way of thinking that you shouldn't be subject to the control of vested interests, let's say. The idea that kind of all Web3 applications are good is not true. Actually, what we've seen, probably half of the Web3 projects or more, I don't have any statistics, I'm just plucking a number out of the air, but it's a lot, are just new ways of scamming people out of money, to be perfectly honest. There is a lot of projects with no intrinsic value, where the sole purpose is to enrich people unjustifiably, and do so in a way which they can probably get away with, because tracing is possible but difficult. Legal recourse is hard to establish. So that's the kind of the bad, messy side. Putting my kind of financial regulator's hat on, as soon as you kind of create a new way of monetizing an asset or financializing a product, which is what tokens have done, because they're tradable. You can create a market in a token, and you can create the market when there is no value, there is no intrinsic value. You can market it, right? You just go and pump the price of the token. You see that now with meme coins. There's a whole website, pump.fun, it's called. You go and create your meme coin, post it on there, try and pump the price, you sell out your bit, make a profit. this is a legitimized activity. In the EU, you can put out a regulated white paper for your meme coin, even though it has no articulated value. So if I'm a regulator and I see this new asset class floating around, immediately I'm thinking, how do I protect consumers? Because people are going to get scammed here. People are going to lose money, real money. So then I have to think, well, how do I regulate it? What is it? How do I characterize it? And that's exactly where we've got to. That's the approach of a regulator and a policymaker, is to look at these products and say, I care about financial stability and I care about consumer protection. None of this stuff is big enough to kind of, take down the whole financial market in Hong Kong, but there's enough of risk here that we need to do something to protect individuals who are otherwise going to be vulnerable to scams, effectively. And that's the problem. And then you get into the technology bit, which is the regulators will say, we don't regulate technology, we regulate conduct. We're technology agnostic. We don't care what the technology is. We've had technology in finance forever. Algorithmic trading, all those sorts of things. There have been innovations in technology and financial markets forever. That's not new. But the point about pinning responsibility on a person, an entity, where there's legal accountability, that's the challenge here. And it's a challenge that's not. We're only still in the very nascent stages. So will we see in every jurisdiction a new legal entity regime for a decentralized autonomous organization? You go and look in Abu Dhabi Global Market. They have a DLT foundation structure. It's specifically designed for Web3 decentralized foundations. You don't have to have a presence there. You can do it remotely, but there's the entire body of English law is kind of subsumed into ADGM. So you have legal certainty, but no one's really set up projects there yet. It's still really new. So will we have that replicated, in all of the kind of traditional markets in 10 years' time? Maybe. But right now we're kind of just dealing with the patchwork of laws that we have and trying to apply them, in a way that makes sense. You only have to look from a policy perspective. 2019, Mark Zuckerberg says, I'm going to issue private money. I've got billions of users. I'm all over the globe. I'm going to issue my own private coin, and everyone's going to use it on the platform. Immediately, Financial Stability Bureau says, no, you cannot do this. We can't allow this to happen. Gets together with all the G20 countries and says, you've got to come up with some rules for this. Now you have stablecoin legislation everywhere. So regulated stablecoins are going to be a thing. That Libra project never happened. So you can just see how, from a policy perspective, you have innovation in the private sector, but it can be stamped out really quickly. And then in terms of manpower of these organizations, you look at Tether, they've got less than 100 full-time employees, I think. It's the biggest stablecoin by market cap in the world. It's run by a handful of people. So the scales at which you can create these kind of commercial enterprises on top of this technology is really interesting. But lots of things to talk about, but some ideas.
Thank you, Simon. That is great insight. Sorry, I might need to press the other three panelists to finish your sharing very briefly, because probably 1 minute each person, because we need to get out of the room very soon, because there's another event. Jimmy.
Okay. Yeah. So do you want?
Don't mind.
Yeah. Okay. Simon has expressed it really well already. So basically, in the end, I think there is no unregulated space. Maybe there's no government regulation, but then there's another regulation. Then it's actually, the private companies that created a particular, environment, a particular system, or a particular, forum where people get together, and then it's privately regulated. And if it's not regulated at all, if basically it's the law of the jungle, so it's law as well, So it is important that there are some ground rules and that you need to protect vulnerable people, inexperienced people from exploitation. Because I only have a minute. Say what the next event is, because it's basically the conference that I co-organize on protecting the digital consumer in Asia. So if any of you were here right now, are interested in that, so we've got a day and a half of further discussion on consumer protection in the digital environment.
Thanks, Jan. So for myself, I tend to think the development of the new technology is more beneficial for both compliance and administration. From taxpayers' perspective, there will be more information available to help them to make sense of those complicated concepts. But on the other hand, it also means tax authorities are empowered with more technology or measures to identify tax evasion or tax avoidance situations. So it means more challenging for taxpayers to avoid their unnecessary tax liability.
Thank you, Jingyi. Ronghua.
Yes, when you asked that question, and that remind me of your friend and most of the people here's friend, Professor Roger Bronsworth, and his book and theories about using technology to govern the society instead of law, or instead of doing the opposite. And that is kind of extreme. However, we also cited his theory in our chapter, and we have seen as the influence of AI and many British universities, and I have colleagues who are taking courses and with Cambridge and other universities, and most of the courses related to AI is about the ethical discussions or ethical problems. On the other hand, and the US professors, and they are observing the impacts of AI and other cutting-edge technologies on students' performance and classrooms. And so we are seeing the world and the scholars are doing on different approaches, and both embracing technology and also thinking about how to set constraints on probably potential harms brought by technologies, and also actively observing the impacts of new technologies on the social practitioners and even the potential legal practitioners and who are currently working at law school. And I don't know which approach is the most useful, but as the currently I'm currently benefited from all of the approaches and trying to still keep watching and what could be the potential brought by the new technologies.
Right, thank you, Ronghua. So before we finish, I want to echo what Norman just said. So we have a series of fantastic conference here on our Admiralty campus. Starting this afternoon, there will be a Digital Consumer Protection Conference organized by Norman. And on May 29th and 30th, right before the Dragon Boat Festival, we have the annual Machine Learning Conference. So scholars coming from all over the world will share their research. And in the end of July, on July 25th and 26th, so we have the annual Intellectual Property Conference, and you are all welcome to join. And thank you for your participation, and please also join me in thanking our fantastic panelists. Thank you.